Hey, everybody. Happy Tuesday. Good to see you. How are you guys doing? Doing okay, hopefully, wherever you are. Um, so, a couple of quick administrative things, and then if y'all have questions, let me know. Let me see my list here. Here's a reminder that your third response paper is due Friday. Um, Hopefully, you received 2 email messages from me about your second response paper. My apologies for the slowness in getting that all sorted out. It just kept slipping through to the bottom of my to-do list. And so my sincerest apologies. And so for that, I gave you guys a fairly long period of time to get that done, but you might as well, some of you I know have already knocked it out. So um, what you hopefully got was 2 email messages, one that was to you and the other that you were CC'd on, um, that was with the second response papers. The one that was to you is the one that you are supposed to review and provide a comment and a question and any other thoughts, that you feel appropriate. And the one that you're CC'd on is the one that your paper is being reviewed. And so when you do it, the key thing is, however you communicate back and forth with each other or back with each other, make sure I'm CC'd on it so I can just check you off and be done with response paper number 2. Response paper number 3 due Friday. Also Friday, a couple of other things. One, you'll see that the assignment for Friday is to just bring a quote. So in the body of materials that we've had, cases, other readings, etc., hopefully there's something that resonates with you. It can be a sentence, it can be a paragraph, probably shouldn't be much more than that. And so that's the assignment. So come with your quote, ready to discuss. And that is what we'll do on Friday during class. I also would like, since it's our end of course on Friday, to just kind of have some sort of hangout after class. I know that y'all are probably tired of doing Zoom stuff, but I thought maybe if we could hang out, for, a little while after class, maybe it's a happy hour. I don't know. We can make it what we want to make it. But so just kind of opening the space, keeping the Zoom room open for that at the end of class. Guinea pigs might be there. They're here all the time, right? It's just they're a little out of frame. They are always here. But maybe for that, they can make their way onto the screen. Y'all haven't seen Hazel yet, so that would be a good add for our course experience. So there will be no substantive discussion, hopefully, nothing related to the course, just a time to sort of reflect and hang out and do that. So that would be Friday after class, whenever class ends. And also on Friday, my intent is to have the exam posted up on Twin. So that will be maybe less happy than the happy hour, but at least it will be there for you to have a look at whenever you like. You're probably getting instructions from the registrar's office about exam 4 and how all the exams will be administered that way and through the registrar's office. And I will, so don't listen to that for this course, basically. I've been in touch with Dean Wilson and with the registrar's office, and I said that doesn't make any sense for the way that I do it and the way that I've always done it. And so I'm just going to keep doing it that way unless you stop me. And they didn't seem inclined to stop me. So, but they did say to tell you guys that all of the messages that they're sending out about exams, do not apply to this exam. So, so you will do it the way that I'm telling you will do it, which is you will go on Twin and download a document, and the instructions will be in there, and you'll upload it back to Twin as well. Okay, and it will be anonymous. That'll be in the instructions. So you go ahead and use your exam ID, just like regular classes. But that's how you'll get it. And so that'll be made available Friday, and it'll be due, and it'll be in the instructions, but it'll be due at the end of the exam period. So you'll have, just build it into your exam period to work on this. Renee's asking, have we been given an exam ID for this class yet? I don't know. Do you not get an exam ID just universal? No, I don't know. I don't know any of the answers to those kinds of questions. So if let's just say hypothetically that, so Renee, can you clarify what you mean by that? Because my understanding was everybody gets an ID that they use for all of their finals. That is not how it works. Some people are saying yes, but Renee, you're saying no. Somebody talk to me, because I want to give you guys a contingency plan if that's not the case.
Am I wrong in remembering that the exam ID could be different from class to class? Because I know that I've got at least one class that has already given me an ID, and I don't have an ID for any of the rest of my classes. So can they
Did
not
that class
be...
have a midterm?
Yes.
Yeah, so there might have been a different one for the midterm.
Okay, that might have been it then. That might be what I'm thinking of.
If somebody else could confirm that what I'm about to say is right, I think that for midterms, you do get a different one for each course, but for finals, you get a single one that will be used for all courses. And I see some nodding heads. That seems to be looking like what it is. So what your exam ID is for finals, which it looks like has not been sent out yet, that's the one you'll use for this. And to be honest, it won't matter, because the worst case scenario is you put in the wrong, which this happens almost every year. Someone will put in the wrong number, and we'll have to figure out who it was, etc. But it doesn't matter at that point, because I've already graded the thing. And so all of the, everything works itself out. But use those IDs. Emily's asking, just to clarify, will we have a limited time period once we open the exam, or do we have the full exam period? You have the full exam period. So don't wait to open it thinking you only have a certain amount of time once you open it. Open it Friday, read it, and write it when you want. This is in part to reflect what I think is the way in which the course operates, which is that I think it would be very difficult for y'all to study and prepare an outline for this course. It's just not that kind of material. And so rather than spending your time studying and creating an outline, I want to give you the questions so that you can spend your time answering the questions that are going to be asked, rather than, sort of guessing about what might be asked, which is what I do in my other classes. Because that process is valuable in, I think, the other classes, and relearning the material, teaching yourself the material, etc. And in this class, I don't think that's necessary. I'd rather you spend the time answering the questions that I'm asking. Yeah, Heather.
Will this be the con law final where you want us to cite cases if it's necessary, or just ideas?
I think you'll have to, you'll see with the questions, but you don't have to cite cases in the traditional sense, like Blue Book style, but you cannot do this exam without referring to cases. It's going to be asking for specific examples from the course, and you can't do that without referring back to the materials in the case. Okay. Last day of the exam period. So all of this will be on the exam instructions, but I think it is, yeah, that second Friday in December, the 11th. But there will be an actual date and time deadline for this exam on the instructions. So you won't be guessing when it's due. Okay. There's a page limit just to set your mind at ease. I think I've told the story of the 80-page remedies memo, but there will be a page limit for this. Any other administrative questions about the exam or about Friday or the response papers? Hopefully everybody's straight on all that. If you did not get emails that were in reference to the second response paper, reach out to me. Okay, we don't need to do it right here, but if you did not get those emails, you should have gotten to. If you didn't get them, reach out to me. Something went awry somewhere. Okay. We all right? And I think that somebody asked this previously, so I'll just go ahead and say it, although I could say it on Friday, and it will be in the instructions. Don't be asking me questions about the exam during the exam period, right? Once it's out there, and I'm not going to be responsive to that. And you can ask them, but you're going to make me feel bad about being rude and not responding to those questions. That doesn't mean we have to be in like radio silence. I will obviously know what the questions are. And so whatever I'm comfortable saying, I'll say. But, there's probably quite a bit that I won't be willing to like have deep discussions about course themes over the 2 weeks of the exam period, or really beginning on Friday. So if you want to have those kinds of discussions, either let's have them between now and Friday, or let's have them after December 11th.
Professor Keel,
Yes.
would you be open to having like a review session before the final?
I don't think it's necessary for this kind of exam. So, nah.
Okay.
Sorry. Any other questions? That being said, of course, if you have individual things that you want to talk about or raise, then shoot me an email and we can do it that way between now and Friday. Okay, so we began the course, I believe, with the Gary B complaint, and the Gary B complaint, gives a lot of the factual background of this specific circumstance in the Detroit schools. And I think we've referred back to it really throughout the semester as like, the sort of big question, which is, does the Constitution have anything to say about what exists in our society and especially in our metropolitan areas, which are schools that don't seem to be doing the job that we would like for them to do. And so it's partially about equity, it's partially about quality. It connects to a lot of the themes from the course. But the biggest way in which the Gary B case connects to the themes of the course is to the idea of using the law to push, pursue, advocate for some sort of social change. And so even though, so that, is a very, very recent example of advocates coming together and surveying the sort of scene and saying, look, we think that this is not proper. And what can we do about it? And I just, let's make clear that the individuals advocating for education, more equitable education in Detroit and all over the country are not just filing lawsuits. In fact, lawsuits are probably unusual in this universe, but lawsuits are a part of a broader effort. And this lawsuit in particular, when I first heard about it, I thought, what a silly lawsuit, you know, what a naive lawsuit is maybe what I thought. That's very, everything they're saying is consistent with the way things ought to be, but is also inconsistent, it seemed to me, with the way um, the way in which education had been treated by courts, and B, was probably not going to receive um, a sympathetic ear from the sort of federal court system, all the way up to the Supreme Court. And so I did a session, and I know some of you were in it, about the value of bringing losing cases. And I think the Gary B case is a good example of this. So leaving aside what happened in the Sixth Circuit, so I want to give you all a quick summary, because you've read the cases, and I know that y'all are sophisticated law students and can figure out sort of exactly what's going on in this litigation, but I want to give y'all some sense of the context of this, of the way in which this unfolded, in order to sort of make a broader point before we get into the nuts and bolts of the case. And so, what I mentioned was the value of bringing losing cases. And so this case, which I thought was a loser from the beginning, was nonetheless hugely important in pushing a conversation, right? So we're having the conversation in our class, but because of the pursuit of this litigation, which failed at the district court level maybe 2 years ago, or maybe a year and a half ago, because of the litigation, it raised the consciousness to where people were asking questions like, is there a fundamental right to literacy? What does the Constitution say about a situation in which individuals are compelled to attend school, but are getting an education that is not even providing them access to literacy? And so even though the sort of legal chances of winning were I think reduced, there was a forum to provide this evidence, which I think was kind of shocking to a lot of people. And there was, it opened up space to have this conversation, okay? And so I think when we had that session, the value of bringing losing lawsuits, at that point, it was between the district court and the Sixth Circuit, right? So the district court is a total loss for the plaintiffs in this particular case. And at that point, I would have said something along the lines of what I've just said, that the conversation changed, and the evidence was sort of put out there about this, and that kind of started to shift maybe at least a little bit of the landscape for other ways in which you pursue social change, right? So even if you lose the lawsuit, maybe the attention draws, increases the pressure for the state legislature to do something different, or for, I don't know that this is like a sustainable model for education reform, but for like a huge foundation or philanthropic organization to invest in communities that maybe they weren't aware or hadn't paid much attention to previously. And so I would have said, even though they lost the case, this was valuable. I think that the Sixth Circuit experience with this case, however, brings out a different value in bringing a losing lawsuit, and that is that you might win. And so you're not going to win if you are, and this is something that, that I struggle with as a person, I feel like I have a pretty good sense of what things are going to win and what things are going to lose. And therefore I defeat things before they even are tried, right? So I'll quit something before it's tried because I know ultimately it's going to be unsuccessful. And I just really admire the advocates in the Gary B case for having the sort of hope, optimism, to even bring the case, to do all the things that we've already talked about, but also a hope that, maybe if you get the right panel of judges, you can win a case like this, okay? And so I know that the Sixth Circuit opinion is a little bit convoluted because though they throw out a lot of the claims, and it feels like a loss in a lot of ways. Buried in there is this, for the first time ever, a court at that level, a circuit court of appeal, so, you know, as close as you can get to the Supreme Court, finding a fundamental right to education, or at least to the basic standards of an education that would deliver access to literacy. Okay. And they make it clear that we're not talking about everybody's got to be reading at the same level. And they provide all the important caveats about how limited their holding is, but it's a winning holding that recognizes a fundamental right to at least a minimally adequate education. And I think it's consistent with some of the cases that we've encountered here, particularly along the lines of when you can frame something as an absolute exclusion, right? I think that is the framing that ultimately turned the Sixth Circuit on this, on the due process point. So we're going to talk a little bit about the specifics, but that's the point that is ultimately successful at the Sixth Circuit. So, you know, when the Sixth Circuit opinion came down, you know, the sort of ed reform, ed law community kind of like, it was like, what, huh? You know, like it was a huge, big deal. So in that like tiny, you know, really kind of pathetic corner of the Twitter universe, it was like a really big event. And it was in fact so big that one of the judges on the Sixth Circuit took it upon himself to call for en banc review of the Sixth Circuit's opinion in this case. And that's really unusual. This was a judge that was not involved in the case at all, didn't hear the original case, but saw the opinion and called for, without, you know, the defendants doing so, called for en banc review. And so why would that happen? And this will give you a little bit of context. Why would that happen? It happened in part because the original governor, who was the defendant in the case, was no longer the governor by the time the case got to the Sixth Circuit. And so though the state of Michigan defended itself in this suit, so this was not the kind of litigation like existed in, if any of you remember, from Con Law Windsor versus the United States, in which the United States government sort of stopped defending the Defense of Marriage Act. It's the first of the same-sex marriage cases, and in which many complained that how, you know, basically you have a suit where the plaintiff and the defendant agree on the outcome, and they're still allowed to go to court over it. So this was not exactly that. The state of Michigan did defend and push for the motion to dismiss. However, once the Sixth Circuit opinion came out, the governor of Michigan, then at the time and now still, said, we welcome this, and said, this is, we think, the right outcome here, even though we were on the losing side of it. And so they did not signal in any way that they were going to push to either appeal the case to the Supreme Court or ask for the en banc review, which you know, could happen. And so they were satisfied leaving the case situated with that Sixth Circuit opinion that you guys read, which would have been an existing positive precedent for a fundamental right to education. Okay, and so they signaled that, and you know that, so that was sort of what was going on. And then this Sixth Circuit judge, sort of recognizing that what's going to happen as a result of this is that they are going to leave the precedent as it stands, calls for the en banc review. And so the decision that you guys read, the longer decision that you guys read, was vacated. It was vacated pending en banc review. Subsequent to that, there was a settlement between the plaintiffs and the state, sort of to address the issue, right? So it's a win on some level for the plaintiffs. The maybe less exciting outcome is that though this opinion does still exist, it's no longer as binding. It's not binding on the Sixth Circuit. It's not as good because it's been vacated by this grant of an en banc review at the Sixth Circuit. So, there was a lot of confusion about what that means in terms of precedent for this case now that it's settled and been vacated and also, but not overturned. It's just a really weird procedural universe in which it sits. But you can see in the opinion, they're inviting the next challenge, right? There's a roadmap in this opinion to bringing the next challenge, which is the challenge that is based on compulsory education, right? They said it wasn't here pled correctly, but there's no reason why you couldn't plead it correctly. And they're relying on some other cases of confinement and detention. And, some of the words that they're using, are really words that I think we've used sometimes when talking about compulsory education, about you're forcing someone to be somewhere for a certain amount of time and not providing them what you say you're providing. And so the roadmap for the next case is right there in this opinion. Whether that will happen or not, whether that will be successful or not, who knows? But that is that story, though it hasn't resulted in an end to inequitable education or bad conditions in the schools of the plaintiffs yet, it has totally transformed discussions. And that, to me, is the value of bringing losing cases. And this case, for a moment, was a non-losing case. A very, very short moment. This case had established something that had never been established at the Court of Appeals level, which was something like a fundamental right to a basic minimum level of access to literacy. So that's the big context in which this case unfolded. And I just wanted to pause here for either questions on that, and then ultimately transitioning to sort of honestly just kind of basic reactions to the two opinions. You had the district court opinion and the Court of Appeals opinion in this case. Caitlin, I see your hand up.
Yeah, I'm trying to understand procedurally what happened. So did the Sixth Circuit have the rehearing en banc, or did it settle and so
Settled.
then they didn't have to? Okay. Okay, that makes sense. Thank you.
The governor and the state really wanted to settle it before that en banc hearing because there was a, I think, well-founded belief that it was going to be reversed and you were going to get a different result. So, you take yourselves back to your legal methods course. And, if you're listing like how powerful a certain type of authority is, a Sixth Circuit opinion that, is affirmed by the Supreme Court would be the best. A Sixth Circuit opinion that's not appealed is pretty good. A Sixth Circuit opinion that's vacated, you're starting to get into some really iffy territory. But a Sixth Circuit opinion that is reversed en banc is pretty much useless, right? It's just a an early draft of the dissent in the en banc case, and so it ends up not having any value at all. And they wanted to avoid that last fate for this case, and so they did not appeal. They settled after the en banc had been granted, but before it had happened, before there had been a rehearing. Other questions about what happened in this case before we get into comments about it? What about reactions? Just kind of, like when we think about back when we introduced the Gary B complaint and how you thought it would turn out or how you thought it ought to turn out versus how, now we in between the complaint and now the opinions, you've had sort of the full scope of the course. Did something surprise you? Did something puzzle you? What are reactions to either the district court or the Sixth Circuit opinion ultimately in this case? let's start with a poll. A, this was really surprising. Let's talk about the Sixth Circuit opinion. Was really surprising. Was B is A. Was not surprising and right on was B, or C was completely wrong. So really surprising, not surprising, and correct. And C is they screwed it up big time. Note that C, it might sound like I'm making it out to be an unpopular opinion in our, within our course. But, think of it as a, on the law, right? On the law, I think C is defensible. In terms of whether or not we should have schools where people are not provided the access to literacy, I don't know that I'm not asking you to agree with that. Take another 10 seconds for you slow voters. Okay, so this is what y'all said. Really surprising was the winner. Not surprising and right on says the middle, and a couple people saying, actually, I don't think that this was the correct outcome in the Sixth Circuit. So hopefully that got y'all thinking, and maybe now y'all have some reactions and questions. David, I see your hand up.
So my question is, so you're talking about bringing like losing cases, and this was probably going to be one, or I guess is one, depending on how you look at it. But so has this launched like a like other, like because of the Sixth Circuit's opinion, like has it launched other suits around the country that are using the same map to try and establish it elsewhere?
Yes. Yeah. And I wonder, like, it's a tricky situation. So I think about it often about suing here, with us making a similar claim. And one thing that was unique in Detroit that isn't exactly present for the most part in Memphis is that it was easier to sue the state and not the local school district, because the state had taken over for the local district. And the advocates, the lawyers and the the school board members here in Memphis are really kind of pushing this same kind of concept that the state needs to invest more in our schools. And so suing the Shelby County Schools, for example, might be at cross purposes with what the Shelby County Schools is already pursuing from the state, as opposed to in Michigan, where it was easy to sort of bypass the local school board because they weren't involved anymore, at least at the time that the suit was filed. And so, it's not so easy to just say, well, we did it here, so we're going to just bring the same suit somewhere else. But it's definitely the case that the commentary in this opinion about why it should be recognized as a fundamental due process right. So note, we haven't talked a lot about due process in this course, but note that this is a due process opinion more than an equal protection opinion. And so there's that part of it that I think people are picking up on and pursuing. I know there's a case in Providence that is doing this. And the second part is that no one has really tested the other theory that is alluded to in the Sixth Circuit opinion about this compulsory education path of getting it to be a due process violation, that it's actually that, they're actually pointing to and trying to make the case that this is an improper detention of people, without providing any sort of justification for that detention. So I think that what you're likely to see is some version of those cases sort of percolating up. But it won't be so fast because you have to accrue a lot of evidence.
Will it have a chilling effect, do you think, on states from taking over districts?
I don't know. I think that has become less, there's been less enthusiasm for that already. And maybe it is related to a case like this. I think there's been less enthusiasm for state takeover districts because really, aside from the one in Louisiana, which was created in really, really special stances in the aftermath of Hurricane Katrina, or which grew in that context. In the absence of that, the state takeover districts have almost been more trouble than they're worth, and they haven't delivered. So we've talked here about the Achievement School District in Tennessee, and that is on the verge of being disbanded. The state legislature is sort of wanting out maybe of the ASD. It's hard to call it a failure, but it hasn't made a real dent. And so I think that the enthusiasm for those kinds of districts is less. What you are still seeing is mayoral takeover, where the state is removing control of schools from school boards and giving it to mayors to appoint school leaders, as opposed to the elected bodies, which has different ramifications on democracy and accountability to the public. Other questions or surprise? What was so surprising about it? That was the majority answer on the poll. It was really surprising.
I mean, with the trajectory, I was like, wait, did I read that right? They're, like acknowledging there might be a fundamental right to something. Like that was what, just really shook me. Like, I felt the same way. I was like, you was like reading from the very beginning of the complaint. I'm like, this sounds awesome, but I know that they'll find some way to, skirt around it, and we'll just have another awesome idea, but it won't happen. And then that fact that they were able to at least get to a point where it's like, oh, there might be a fundamental right to something, which is huge. And then my immediate reaction was, well, this is awesome. I'm sure something will happen and it will either be reversed or appealed. And now that I know the rest of the story, so I'm like, well, makes sense. But still, seeing the trajectory we've been recently going on, it gives me hope that there is some light at the tunnel, that that we can move forward in a post-Rodriguez world. So
And it's kind of like blink and you miss it, because there's so much, like they failed to plead this and they failed to plead that, and we think that's a great idea, but they failed to plead it, included in their pleading, so they lose. And then all of a sudden at the end, they're like, wait a second, they just said that there's a fundamental right to access to liberty, and they sort of take the judicial restraint point head on, and et cetera. What about others? Yeah, Caitlin.
I had an initial reaction, but I tried to withhold it because I feel like I talk too much. So anyway, I did want to respond initially, but when I first read the Gary Vee complaint, I didn't understand a lot of what was going on. I was kind of, I think I thought the way that you did, as far as like, I thought it was kind of silly, especially having been in the classroom. Like, well, this is kind of how my school was too. And it doesn't seem like I could have done anything about it legally, certainly. And then now that I've also taken con law while I've been in this class. And so reading this case, I just understood more of what was going on. I'm like, oh, I know when I was reading words like fundamental right before, I thought it was just like the court kind of like talking about a really important right. I didn't understand that it was like a term of art. And now, so I think I'm like everybody else where I just understood how significant this was that the Sixth Circuit was saying what they were saying, and surprised to see our circuit that we're in saying that, because typically, you know, like things that are a bit more progressive seem to come from different circuits and not from our area. So just kind of those things, like fully understanding what this means. And I wish it hadn't been vacated, because I think that would be really interesting to see what happens next.
I don't know. Be careful what you wish for, because if it had been en banc heard, then you might have gotten a bad outcome. And I think it's pretty safe to say that if we had gone to the Supreme Court with a case like this, it would have been an even worse outcome. But you never know, right? Like that's why you play the game. It's a lot has changed on the Supreme Court since Obergefell. And you can see, and this is just an interesting sort of bigger picture law and social change kind of thing, how law and social change movements feed on one another, right? So what happened in Brown was a model for use of constitutional law in particular to reflect the way in which society could change, right? And obviously we see that that's really hard and complicated, and it's a lot easier to change the way that the Constitution is interpreted than to change the way that the world is lived. But it provided a successful model for constitutional change. And that model was followed by the sort of legal pursuit of same-sex marriage and the legalization of same-sex marriage, or the decriminalization of same-sex relationships, right? So all, you know, however you want to frame it, the exclusion of same-sex relationships from marriage. And so a case like Obergefell, which is kind of like the culmination of fundamental right to marriage that cannot be denied to same-sex couples, is an expander of substantive due process. Well, that whole model is built on the Brown model. And then from Obergefell comes the Gary B argument, right? Note that this argument came not 15 years ago, when the major area of substantive due process was abortion rights and privacy. Here we have from Obergefell an example of a different type of substantive due process right that maybe you could connect literacy to. I'm not 100% sure that there's a perfect one-to-one comparison between access to literacy and access to marriage. That it's not exactly a perfect fit. But what Obergefell did was open up a conversation about what should be included in substantive due process that might be beyond just privacy and sort of personal autonomy. And that's the case upon which the plaintiffs built their case, right? So the plaintiffs being, you know, if not legally, then in sort of spirit, heirs of the Brown plaintiffs, right? We are individuals who demand access to an education that gives us an equal chance in life, right? That's what they're asking for, just like that's what the Brown plaintiffs were asking for. And so it's this sort of, even though the Brown litigation seemed to have petered out by this point, it had fueled other changes in constitutional law that then allowed for this argument to be made. So obviously there's the really narrow, like what happened in this case, which I guess we'll talk about in a second. But there's also the sort of big scope of the work of using litigation and law and the Constitution to pursue a broader social change. So there's that element to it as well. Y'all can tell I have a lot of thoughts about this case. And so I'm trying not to just dump all my thoughts. I'd love to hear sort of thoughts, questions, reactions from your end as well as we continue through this. Anything else before we start going to the nuts and bolts of the case? What are ways in which it connects to our course, right? What about the framing of this case? Or were you convinced that this is, that I would posit that this is framed as an exclusion case. Is it? Is that why they win? Because this is an exclusion case? Or is it different, a different kind of case? Remember, we've seen exclusion cases, right? Obviously, VMI being a big one. Lau being a sort of functional exclusion, Plyler being an exclusion case. Is this like that? Or is the due process angle different than that? Yeah, Heather.
I mean, I don't think it's necessarily an exclusion case. It could be more of an implied exclusion case, kind of, because they're not being excluded necessarily from learning in general, like the school.
Mhm.
They're being excluded from learning in a particular way. And so I personally think that's why it was decided the way it was, why they were only given this like narrow holding rather than giving them like a full 10 feet forward.
Because it is a really narrow holding, right? Like what I'm celebrating is that it wasn't a complete loss. This is not like a shining, everybody gets to get, to the top of the American education system. And so you're saying it's limited because it's not actually just an exclusion, or it's not fully an exclusion.
Yeah.
Yeah, go ahead.
I was just going to agree with you. Just say, yeah, that's what I was saying.
Yeah. Alexa and then David.
I think it's kind of an exclusion case, to me at least, because they're being excluded because they don't have access to literacy. They're being excluded from being able to, like down the line, it's kind of like a future exclusion. They won't be able to participate in society at all, in the democratic processes of society, because they lack the basic education that they need. So it kind of is exclusion.
And we've seen if you can make it exclusion, then you're going to win. And so that is, sort of a framing tactic that I think that they do try to utilize here. The due process does make it a little bit different. David, you had your hand up also, sorry.
I totally agree with Alexa that that is an exclusion for the right to jobs or voting, or you need a basic level of education to being able to read. So no, she's spot on.
Lindsay.
Can you hear me now?
There you go.
Great. So doesn't the court in the end kind of say that they were sympathetic to the exclusion type claim, but that they wanted it to go back to be litigated further? That they hadn't they were pleading an exclusion case, but they weren't showing people that they had extended good education to compare to the other students, right?
Yes. So on the equal protection point, which is where we have mostly been in this course, the Sixth Circuit is not on board with an equal protection violation here. And Lindsay, you point out the primary reason why, and that is that there is not a relevant comparison to these students. What would, Lindsay, if you had to, what if you had to frame it as an equal protection case, how would you do so? What would the comparison be to say some students are getting X and some students are not?
I think what they tried to do in the case, and I'm not entirely sure, but they had basically alleged that other schools in the state were receiving good funding. They pointed out the 3 categories, and I can't remember what all of them were, but one of them was facilities. Yeah. And they were saying that their students were sitting in the floor. So what they would have to do would be to show schools where the students were not sitting on the floor, right?
Yeah, so it was teachers, facilities, and materials were the categories. And I think it's actually even more difficult than what you've put out, because aren't there schools where there aren't students sitting on the floor?
I would imagine.
Of course, right? Of course, there are. What the Sixth Circuit was asking them to do, in the district court as well, was to show a similar place that the state had intervened with that was getting better outcomes than this. And the word that I just used in there is a real problem for this case overall, and it's outcomes. Because Lindsay, I'll ask you real quick, what is the way, or I'll ask anybody, so Lindsay we don't have to wait for Lindsay's mute to stop, to turn off. How are they proving, we mentioned already the teachers, facilities, materials, but what was their primary evidence for that these schools delivered lack of access to literacy?
I mean, I would think, wasn't it the test scores and like the outcomes? Yeah.
Yeah, outcomes. And so why is that problematic?
Because they would be disparate or different for that school versus other schools in the state.
And so why does that mean that, what is the problem with relying on performance, right? There's a major issue that the court recognizes here on the equal protection claim in particular. One is that we're looking only at outcomes. And so how do you determine what causes a school to have low performance on state tests, right? They're talking about, materials, teachers, facilities, but what else goes into the mix?
Like the student's contribution.
Yeah, right. So there's a problem in that. And so if the student is the problem, right? If I'm the state here and I'm defending this and I'm saying, well, look, we provide funding that's really no different than, the formula is no different than what's provided in other school districts. The performance here is worse. Yeah. And we think that's bad. And we're taking steps to address it, but that doesn't mean we're not providing access to literacy here. There's another potential variable, and that is the student contribution. And I don't think that the state would necessarily, go this far, but to say that, like, at some point it's on the student to take advantage of what is there for them. And we can't just say because they scored poorly that the state has failed, right? It's a causal problem. And so they're saying that you haven't pointed to a specific state policy that is the cause of that outcome for these students. Okay, you haven't pointed to a specific state policy or state decision that is the cause of the outcome for these students. So, for example, in Rodriguez, they were trying to point to the state's financing scheme and to say that's the cause. The way that you fund schools is the cause. But here, every district in the state was subject to the same financing scheme. And in fact, the financing scheme was not producing the kinds of disparities that we saw in Rodriguez. And so this isn't a funding suit, right? The reasons for the teachers and the materials and the facilities is not because of wildly inadequate funding, or it probably is wildly inadequate funding, but not wildly unequal funding. And so, when you look at outcomes and you say, well, there's a cause, there's a variable here, another cause, maybe you would say it's an intervening cause. It becomes very difficult to sustain an equal protection claim in this circumstance. There's a lack of comparison. There's a lack of potential ability to connect the outcomes back to specifically state policy. And that's what the court is asking for. Yeah, Rachel.
Hi, kind of going off that, I know the courts go into, they have to take a look at, their judicial legitimacy and stuff, but is this really just a fear of courts, really like of a floodgate thing of them saying, yeah, there is a fundamental right, and then you have places like Michigan where it's not a funding problem, it's just a huge problem with just lack of necessary resources. I don't see how courts could ever rule that there is like a real fundamental right to education and our education system not be like flooded with lawsuits. And I was just wondering, do you think it's like possible to like, do you think it's possible that, this could ever be sustainable where there is a set of standards a school must reach?
It should be. If there's a floodgates problem, so this one's a hard one for me to answer, Rachel, because the con law professor in me wants to say that the entire function of the judiciary does depend on striking an appropriate balance between getting itself involved and not getting itself involved, right? Legitimacy is the way we would talk about it, judicial restraint. And also, when you talk about floodgates, you're talking about judicial economy, like incompetence. We've talked about that in the IDEA context. When there has been a right, all of a sudden you have courts having to decide educational policy, like should this student get a sign language interpreter or not? Like that's not a typical court thing to do. And so all of that, I understand, like as someone who sort of thinks con law, at least in the spring. But the sort of education advocate person part of me says, like, if there's a floodgates problem, isn't that like a problem, right? Like if there's so many of these suits that could be out there, like, doesn't that evince that the way that we're currently doing it is not working? Like there's only a floodgates problem because there is a lot of problems like this out there. And so, so the education, the con law person is tugging me towards like reality. But the education advocate is saying, like, isn't that exactly why there should be a right here or some sort of significant change here? Because without it, there's no way to address the issue. If the courts aren't going to force someone to do it, then what's to think that that there will be anything to address this? Of course, then the other part of me, some other part of my brain is saying, but Brown, the courts can't fix it, right? The courts are limited in what they can truly accomplish in this space. Because there was floodgates after Brown. And I would say that was a good thing that the floodgates were opened. But it also was not ultimately, sort of hugely effective. So Rachel, I don't know is that responsive to what you're saying? I think absolutely they're thinking about that. And you can read it in the opinion, right? They're saying don't get us wrong here. We're not saying that every student has to get to the same level of schooling, right? The same level of performance. The Constitution can't do that. So they're being very cautious about it. But still at the same time being very bold, right? This is a new kind of thing. It's a really that tension is there. So Rachel, I'm sorry, was that responsive to what you were saying?
Yeah, I'm sorry to give you like an existential crisis. I was just, I agree with you. The court was very, like, I thought cautious, but bold, but I agree with you. I just think our courts are so cautious that doesn't really fix anything in education.
No. And I think, so I'll, be the devil's advocate. That's not the court's job, right? They would say that that is, we defer to the legislature, we defer to localities. If they want to intervene from an educational standpoint, then go for it. We're all for it. Even the district court was saying, like, this is horrible. Something's got to be done. Just not through the Equal Protection Clause or the Due Process Clause. Lindsay's asked also here, and I think that this is worth pointing out, that there is another map provided in this opinion to a future case, but I think that it's a little more difficult of one, and it's to point to the specific government action for the equal protection claim. And I think that it's more difficult because it's very, very hard to say which particular government policy contributes to a situation like this. So if I asked you guys, what specific government policy contributes to schools that are like the schools that the plaintiffs attended in the Gary B case, what might you list? Lots of really small, terrible ones. Good. Attendance zones, who goes to school where, school district lines. What else? Right, in the case they say, like, if this were a different school that was serving different students, this would not be tolerated. Like, and so then why is it this school serving these, funding, right? The funding scheme. I think that the answer to my question is all of them, like every policy, how teachers get assigned, how students get assigned, how district lines get drawn, how curricular choices are made. There actually isn't any that you can really exclude from this. It's the cumulative effect of all of them that contributes to this circumstance. And so that's why I think to address the point that Lindsay raises, which is, they are also providing a map for an equal protection claim. I think that that's a harder one. I think that one's going to be more difficult because I think it's harder to point to a specific thing. To the extent that there's one that you point to, it's the compulsory education, right? The fact that you have to go to a school. And I think that connects more to a due process. Like note the kinds of cases that they're comparing it to in the compulsory education context, right? This is an individual with sort of intellectual disability that's been confined for his own safety in a state mental institution. Like, that's the precedent that they're using for what's going on here, that there's some obligation if you restrain someone's liberty to provide them something, right? Like, if you're going to force us to, let me scroll up to this portion because I want to use the specific words. Arbitrary detention. I'm on page 4 of the Sixth Circuit opinion. Detaining, confining, arbitrary detention. Like, they're talking about like that the kids are being imprisoned essentially. And they say, 99% of the time, we think that's okay because they're being provided an education. But if what they're being, at the same time, this is on page 5, forcing students to attend a school in which they're simply warehoused and provided no education at all would run afoul of the Due Process Clause's protection Such a deprivation would bear no reasonable relationship to the state's asserted purpose and thus would be outweighed by the individual's interest in liberty. And then, of course, they go on to say, but they didn't plead that correctly, so they lose. But that is a really, really, really powerful bit of language and an indictment of the education system and of compulsory education. So I think that to the extent that there's a state action that we're looking at right now, it's compulsory education, which of course, let's say you're the state and your compulsory education law is going to potentially make you liable for doing better. What might you do? Think about what Texas did. Somebody's talking.
I just say get rid of the compulsory, but then that could also affect their federal funding. So but maybe just not make it compulsory anymore.
We have two examples of this in our history, right? One is in Plyler. They relieved undocumented individuals from having to comply with the compulsory education law. So it wasn't a straight repeal of compulsory education, but they said, well, we're not going to provide education to those students, so we're going to excuse them from thanks so much. You're being excused from compulsory education. The other example is in Virginia after Brown. They just said, we're just not going to have schools. So we're not going to have schools. So there's no more compulsory education. They allowed for counties to decide if they wanted to be exempt from the compulsory education statutes. So I wonder, like, if compulsory education is vulnerable after this, is a response to just not make education compulsory anymore. Yeah, Renee.
I think that we're probably in a lot of danger of that right now, especially post-COVID, because that's just given a lot of, everything going on right now has given a lot of fuel to that fire of people are realizing that there are ways to educate their children, be they good or bad. There are ways to do it that are not beholden to the public education system, and they've had to realize that out of necessity when all across the country public education is having to take so many weird shapes and forms and make dues, and people not liking it and pulling their kids to do something else instead. And I think it's kind of been a little bit of a wake-up call to a lot of people, for good or bad, that things could happen without the system that we have in place. Does that mean that we change and fix the system, or do we just kind of trash the system? That's the problem, though.
And I would argue in this context, and I think we talked about this way back at the beginning as well, like, is the compulsory education for the purpose of education, or is the compulsory education for the purpose of allowing adults to go to work? And I think that has been placed front and center in the COVID situation as well. It's also worth noting that this, and I think, Renee, you're exactly right, that COVID sort of lifts this up as a topic of conversation, but so too do the trajectory of the policies pursued by the Betsy DeVos Department of Education, in which I think it's fair to call it an assault on public education as being the default. I don't know that I would go so far as to say it's realistically likely to lead to an end of public education, but it's clear that the policies of the DeVos Department of Education were aimed at elevating non-public options as sort of on equal footing in every way with, and maybe even advantaged over public options. That's something that Derek Black, for example, is like on fire about, that it's been an unrelenting assault on the idea of public education, which kind of goes back to our purpose discussion way back at the beginning. Why does a society have an education system? An education system in which the populace relies upon the government to provide education for the vast majority of people. Okay. I'm following the chat here. Jonathan, you're saying kids are already less free, and so maybe compulsory education is less offensive. Is that the rub there, that they already can't go wherever they want, whenever they want? They don't have the same kind of liberty. Yeah, just confusing. I mean, I think that's fair. But just taking, again, that portion of the opinion, which again, they get to kind of skirt over, right? They can say all this stuff about warehousing, which is, on some level an indictment, but on another level, it's kind of offensive language. It's easy for them to say it and then avoid actually having to make actually having to make a decision on it, right? They're saying you could argue compulsory education is a due process violation here when you're not getting an education, but we don't have to actually address that, so it's kind of a convenient thing for them to be able to raise and then address, or not address, raise and then not address. Yeah. If the state required a group of people to sit in a building for several hours a day without any justification, such a restraint would clearly offend their right to liberty. And so if compulsory education is constitutional, it must be because the relevant state interest outweighs any deprivation of liberty, right? So, saying that basically they're making a group of people sit in a building for several hours a day with no justification. A really interesting theory. So we've kind of talked about the nuts and bolts, I think, in this, but I do want to make sure that we're on top of that before we close here today. There's 3 claims being made that this is a problem. One was the equal protection violation. We've talked a lot about that the problem there was twofold. One, a lack of comparative analysis, right? So for equal protection, usually you need to show that there's some sort of discrepancy, a classification and then differential treatment based on that classification. And that they couldn't show the sort of comparative prong of equal protection. And then second, that there was a lack of a specific state policy to point to that was creating that disparity, right? That's the sort of problems with the equal protection claim. Then there was the due process compulsory education claim, which we talked about quite a bit, which the court seems ready to embrace, like in full, based on these facts, but can't because of the pleading problems. Okay, and so they say that basically you never pled that. And then the third is the straight substantive due process claim that is access to literacy. So note that it's access to literacy, and it is not a fundamental right to equal outcomes in education, but we're talking about access to literacy. And they're saying that is so much a core part of our nation's history that it is included in the liberties that are protected by the due process clause, right? So it factors in to substantive due process. And that's where they find that, yes, this could be a violation, right? Eventually it has to be remanded. This is a motion to dismiss. So we don't really know what would have ended up happening, obviously, if the case had gone all the way through. But what I think is so poignant about that outcome is that the birth of substantive due process comes actually in cases like Pierce versus Society of Sisters, way back at the beginning of our semester, that parents have the right to determine where their children go to school, that you can't mandate public education. That and several other education cases right around that same period in the first quarter of the 20th century. that's really the birth of substantive due process. And then it kind of goes away for the most part from an education standpoint. It starts being more about privacy and ultimately marriage. And but here in the Gary B case, they're taking it back to its roots that substantive due process has in education. And so that's the case. There's a lot more to it. You know, I'm looking at my other notes, you know, like, is it a negative right and positive right? I think that that's a really, that's a really hard needle for them to thread in this case, that it's a negative right, that the state is actually impeding their ability to have literacy, rather than the state is failing to positively provide access to literacy, that but for what the state did, right? The argument is, but for compulsory education, we would have access to literacy, which I think is kind of tricky to argue. So there's a lot more to this case than even what we've talked about, you know, in this class. And maybe y'all will have quotes from this one to discuss on Friday. Okay, so I'll stop here. We'll pick up on Friday with quotes. I'm not going to pick up with your response papers, but the response papers will be due on Friday. Make sure you're doing your response paper 2 exchanges. Come with a quote and stick around for happy hour after class on Friday. Hopefully it'll be like it is today outside, and we can all go outside and sort of, in whatever way that happens now, be together.
Professor Keel.
Yo.
I have a question about the upcoming response paper due on Friday.
Okay.
I was wondering if I was able to write on a particular topic. I'm currently writing an op-ed about how the coronavirus is destroying the IDEA and how the standard appropriate should be defined differently. I was wondering if I could kind of rework what I'm writing about already into a response paper, or is that?
Yeah, that sounds great.
Okay, cool. Thank you.
Yeah, and like the response papers are op-eds. Like at the end of the day, that's kind of the model. So that sounds like a perfect thing.
Okay, thank you so much.
Mhm. Haley, Alexis, are y'all here for me?